The demarcation between domestic and commercial cases has always been blurred in the case law. In Kobe and Human Roles Management, the House of Lords held that a particular relationship is domestic if the parties have a social relationship with each other. For example, in Inwards and Baker, the relationship is one of father and son, and in Gillett and Holt, the relationship is a surrogate family. Finally, in Janice and Rice, the claimant is a gardener who provided daily care to the defendant. On the other hand, in Thorner and Major, Lord Neuberger held that the relationship involved in the commercial cases is entirely at arm's length. There are 3 points to note about the demarcation between domestic and commercial cases. First, any social or quasi-familial relationships involved between the parties would be very indicative. Secondly, in commercial cases, with arm's length transactions involved, the party usually have certain degree of commercial experience or accessibility to legal advice or assistance, so that they tend to know better in respect of the facts of making the assurances. Thirdly, it is also a consequence that there are varied expectations among the claimants in different cases. First, in commercial cases, parties usually expect that they can be given a certain set of legal rights, and some legal procedures would be conducted later. For example, signing a contract. In contrast, the claimants in domestic cases, after the estoppel was created, might not have a clear idea of the quantum they may get. What they concerned instead was some beneficial interest in the property. The starting point is a case of Kobe and Newman's Road Management involving 2 property developers, where the House of Lords held that proprietary estoppel was not established on the fact. However, in the later case of Thorner and May, involving similar risk-taking behavior, the House of Lords held otherwise. In Thorner, Lord Neuberger was aware of the need to reconcile the outcomes of the 2 cases. To that end, he did this both doctrinally and using the domestic and commercial dichotomy. For the dichotomy, he noted that Kobe was a commercial dispute between 2 property developers who are presumably well aware of the cautionary and channeling functions of the formalities in land law, whereas Thorner's was but the latest cases in a long series of inheritance representation cases arising within the domestic cases, and reflects the court's sympathy for the claimant in the form of less exacting judicial standards. There are some scholars arguing that the domestic and commercial dichotomy is fallacious. For example, May thinks that the normative position of Mr. Kobe and David Thorner's are closer than we have thought about it. Me argues that whereas Mr. Kobe is a commercial example of commercial risk takers, while David Thorner's was a domestic risk taker. Furthermore, Mies argues that the factual boundaries is far from secure. However, we think that the lower court are dealing with these boundaries very easily and without any difficulty. So we think the force of this kind of criticism is very weak. After all, we think that the laws operate by imposing categories onto the unruly world, and it is wisdom that there are different legal characteristics and different categories, and it is for the judge to elegantly apply. So as long as the dichotomies work most of the time, we think it is practical. And the court may sometimes look at the factors in different circumstances, for example, the sophistication of the parties, and more importantly, the relative significance of the commercial and domestic elements of the relationship.